Child labor has been an ongoing issue throughout the history of the United States. It became particularly common, however, during the Industrial Revolution. Instead of attending schools, young children spent, on average, 16 hours per day working in factories. The primary causes of the increase in rates of child labor include the influx of immigrants who needed children to support the family, as well as the market revolution, where people began purchasing goods for comfort at lower prices as a result of the establishment of factories and new technologies. Not only did children work long hours in dangerous conditions, but they were also subject to abuse if they complained or ignored orders. Private businesses and factories preferred hiring children because they were a source of cheap labor. Oftentimes, children were only paid 10 to 20% of an adult's salary, and orphans were typically not paid at all. Though over time, reformers established laws to minimize child labor, there were many loopholes to these laws, and they were hardly enforced at first, causing the prohibition of child labor to not be enforced until 1949. The idea of creating reforms for child labor began in the 19th century, when the public's attention was turned to this issue. In 1832, New England unions condemned child labor and held multiple protests against it. In addition, writers such as Charles Dickens, who wrote about the horrible truths of child labor in Oliver Twist, and photographers such as Lewis Hine, who spread evidence of children working in poor conditions, helped spread awareness of the evils of child labor. Then, in 1836, Massachusetts created the first state law regarding child labor. This law required children under the age of 15 to attend school for a minimum of 3 months per year. In 1842, the question of whether or not labor unions were legal was raised to the Massachusetts Supreme Court in Commonwealth v. Hunt. Lemuel Shaw, the Chief Justice, ruled that the act of combining was not illegal, though only combining to accomplish some criminal or unlawful purpose could be prosecuted. Justice Shaw thus legalized American labor unions. Massachusetts also limited children to working 10 hours per day in 1842. Though many states did the same in passing laws limiting child labor, they were hardly enforced.
I was 11 years old when I went to work in the mill. I was so little that they had to build me a box to get up on to put the sock in the machine. We worked 12 hours a day for 50 cents.
In 1892, the Democratic Party adopted a plank in their platform that recommended banning child labor for children under the age of 15. Though by 1899, 28 states had passed laws regulating child labor, no laws were strictly enforced until 1908, when the case of Muller v. Oregon was presented to the United States Supreme Court. Kurt Muller was fined $10 for exceeding a woman's workday to over 10 hours. The decision by the Supreme Court unanimously upheld the constitutionality of Oregon labor laws and affirmed Muller's conviction. Just 8 years later, Congress passed the Keating-Owen Act. This act banned the interstate sale of any products created by child labor and regulated the number of hours children could work. However, the Keating-Owen Act was declared unconstitutional by the Supreme Court only 9 months later in Hammer v. Dagenhart. Roland Dagenhart, who worked in a cotton mill in North Carolina, sued, arguing that the Keating-Owen Act was unconstitutional because Congress did not have the authority to regulate the commerce of goods manufactured by children. The Supreme Court recognized this and repealed the act. Congress then enacted the Revenue Act of 1919. Also known as the Child Labor Tax Law, companies that employed children under 14 would be taxed 10% of their profits. The Drexel Furniture Company was found to be in violation of this law later that year out of protest. The Bailey v. Drexel Furniture Company was presented before the Supreme Court, where Drexel argued that the tax was unconstitutional because it regulated manufacturing. The Supreme Court ruled in favor of Drexel and declared the Revenue Act of 1919 unconstitutional. Once again, child labor reforms had failed their original purpose.
My mother used to say, "What are you doing in high school? Go to work, you make a few dollars." She would wash dishes, do anything to make $1.
In 1924, Congress made another attempt to illegalize child labor, but not enough states ratified the amendment for it to become law. The Walsh-Healey Act of 1936 set safety standards, minimum wage, and child provisions on the federal level. Perhaps the most important act passed, though, concerning child labor in the United States was the Fair Labor Standards Act, signed by President Franklin D. Roosevelt in 1938. This law put many limits on child labor, including the right to minimum wage and time-and-a-half overtime pay when children worked over 40 hours per week. The Fair Labor Standards Act additionally established an age minimum of 16 for working during school hours and a minimum age of 14 for certain jobs after school. Work that was declared dangerous was restricted to adults.
The hours for the school hours were scheduled around the time that children could work in the morning and in the afternoon. The argument can be made for child labor being complementary to learn skills.
Remember Hammer v. Dagenhart, the case that repealed the Keating-Owen Act? Its ruling was overturned in the case of United States v. Darby Lumber Co. in 1941. The Darby Lumber Company violated the Fair Labor Standards Act and appealed its case until it reached the Supreme Court. The court held that Congress had the right to require companies to obey production regulations under the Fair Labor Standards Act, and that employers must keep records of their compliance with the law and would be held responsible for failing to do so. The final major compromise established concerning child labor in the United States was made in 1949 when an amendment to the Fair Labor Standards Act directly prohibited oppressive child labor. Today, though child labor has been mostly eradicated throughout the United States, it still remains an international issue. Senators such as Tom Harkin have condemned child labor through the encouragement of passing the Child Labor Deterrence Act, which would ban the importation of products made with child labor. In addition, contrary to common belief, children of migrant workers have no legal protection. Farmers may employ them outside of school hours legally. These children can get little schooling because they move from place to place.
In terms of whether there is child labor still happening in the U.S., absolutely, and you can still find it in agriculture because for agriculture there is less regulations.
Overall, child labor in America has been limited to after-school hours. This compromise has been beneficial to students who wish to make money while receiving an education.
And this was the last song of Billy the Kid.